beg to mention item number 17 of daily
17.
list. 17 of
Yes.
daily list.
This for what? This case.
Yes, Lordship. Lordship, engaged counsel is unable to come to the court as he is unwell. Matter may be adjourned for 2 weeks.
Why miscase? Miscase for what?
Yes, for restoration, Lordship.
Restoration.
Yes, Lordship. Due to some oversight and some mistake, we have missed it in the cause list, Lordship, the writ petition.
Will allow the miscase. What's wrong?
Lordship, I am not aware of it as the engaged counsel P. Talukdar is doing the matter, Lordship, and he is unable to come to the court. He is unwell, actually, Lordship.
Are you in the case?
Yes, but brief is not with me, Lordship.
Get the brief. Give her. We'll see. We'll take it up.
Okay, let the matter be reached, Lordship.
This who is for the GSM, sir? 17 for restoration. We'll see. We'll restore it if possible. If you don't have any objection. All right.
Yes, sir.
May it be please, your Lordship. Lordship, I beg to mention item number 1, Lordship.
Yes.
In this case, Lordship, we will file additional affidavit, Lordship. So, 2 weeks time may be allowed to file our additional affidavit.
For what? For what? What additional affidavit? Why additional affidavit is required?
Lordship, in this case, I'm not in this case. I'm on behalf of B. Thakuria, Lordship.
On the prayer of MS
S.A. Khalifa, on behalf of B. Thakuria.
S.A. Khalifa, learned counsel appearing on behalf of?
B. Thakuria.
Lordship,
Yes.
Lordship, kindly fix the matter on 4th of November. I'm for the petition.
Appearing on behalf of MS NS Takhuria, learned counsel for the respond number 4, 5, 6, 7, 6 and 7. Press for it is granted. List this matter after 2 weeks. So
No, Lordship, kindly.
the learned counsel for the respondents to file additional affidavit. What is the matter?
Item number 1. I'm for the petitioner.
Yes.
Lordship, kindly fix the matter.
After 2 weeks. We'll take it after 2 weeks. What is the matter?
Dilip Kumar Sigia.
That is the name of the petitioner. What is the matter about? What
No,
is the
Lordship.
case about?
Lordship, I am on behalf of the ASMO. I have no idea about this matter.
If you have no idea why you are asking for a fixed date, don't appear before the court without any idea of the case.
As per the instruction of the senior.
Next.
My lord, the petitioner has been given appointment, my lord. It has become infractuous, my lord, actually. My lord, I am giving.
Nobody is appearing.
Last time we are supposed to get instruction, I think.
Last time they wanted to take instruction whether appointment has been made or not. And he has joined also. Next page.
This for appointment is what?
Is for appointment as, my lord, junior technical diesel A1 level.
Okay. Initially, he was not appointed.
He was not appointed,
He was
yes.
not selected.
Yes.
Why you
No,
are,
he was not selected, my lord.
so
Guilty
why
of
you
that.
are appointing them now?
No, now, my lord, after second, my lord, round, my lord. Yes.
Not appears for the petitioner. On phone,
Second phase joining.
matters relates to the next paragraph. Writ petition pertains to selection and appointment of junior assistant technician.
Yes.
in diesel trade.
Yes.
Next, in ONGC,
ONC.
under ONGC. ONGC. Next paragraph. Learned Council, Learned Senior Council, Mr. D.N. Sahiwala, by placing the instruction,
Yes.
instruction dated 6/05/2023. Who is Murgan Barali? Oh, there.
This is the appointment letter.
This is the appointment letter. my lord.
Which shows the
Second page is
Which
the
shows that-
joining report.
no instruction dated copy of the
Appointment letter.
while placing the appointment letter dated 16/05/2023, by which the petitioner has been appointed as technical
Junior technician, diesel.
junior technician
Within bracket
in the
diesel.
diesel trade under ONGC.
Second page is the
Submits that.
joining letter.
And he has joined also, my lord. Next page is there.
The matter has become. We further submitted the. Has been appointed, Mr. But that is also saying that the petitioner has joined on 05/06/2023. Therefore, he submits that the matter has become infructuous. Just delete the first one, then you explain. Accordingly, the next paragraph, the writ petition is still closed, dismissed as infructuous.
Much.
May it please, Your Lordship.
Yes,
Kindly produce the last order, last line, last paragraph.
Lordship, on 28th, we have written to the PCCF to send back that we are yet to receive the pension papers of the petitioner, Lordship. So it's the PCCF has to make the call, Lordship. No.
therefore,
Accountant General.
Accountant General.
No, Lordship, my friend will respond. Let him take instruction. What is the latest position, Lordship?
Have you received the provisional pension?
Yes,
No issue.
no issue.
It's a final pension.
Final pension.
Not Mr. Will then,
Something like
how much time?
Lordship, 3 weeks maybe.
3 weeks.
Next time, please.
You also inquire about that. Just request them to send it immediately. Not Mr. Sales and Council for Deputies. Expert Mr. B. Chakraborty,
Lordship.
Land Council, appearing on behalf of the Accountant General by placing the copy of the letter dated 28/10/2024, addressed to the Principal Chief Conservator of Forest, Head of the Forest Force, Assam, by the Senior Accounts Officer, dated 28/10/2024. Submits that. The Office of the Accountant General has written to the concerned authority to forward the pension case of the petitioner. Next paragraph. Mr. I. Thakur, Standing Counsel for the Forest Department. President, he may be granted some time to obtain instruction as regards the forwarding of the pension papers of the pension case of the petitioner. Have you considered about that it may not be listed after 3 weeks so as to
Well,
enable,
kindly fixed a date, ma'am.
so as to enable the Land Standing Council for Forest Department to obtain instruction? It is expected that the authority in the Forest Department shall do the needful, forward the pension papers of the petitioner to the Accountant General as expeditiously.
Lordship, may I pray, Lordship, that particular line, Lordship, there is a criminal case
Pending against him.
Whatever.
But Lordship, this would amount for direction, Lordship.
Unless you have withdrawn or cancelled partially any order that he is not entitled. Anyway, last line. This after 3 weeks.
Well, kindly fixed a date, ma'am. Pension increment.
Keep the date.
Plus.
May please, Lordship. The matter relates to confirmation of the appointment, Lordship.
Yes.
In this case, what has happened, Lordship, my name has been recommended by the district level scrutiny committee, Lordship. When thereafter my name has been rejected by the state level scrutiny committee, Lordship, after 3 years, Lordship. Clearly violating the OM dated 1/5/2015, Lordship.
Yes.
Lordship, kindly,
Where is 15215?
Lordship, kindly peruse page 52, Lordship, Annexure J, Lordship.
Yes.
This is the OM, Lordship.
2015.
1 June 2015, Annexure J, Lordship. And kindly peruse page 55, Lordship.
Yes.
Lordship, Principle 4, Lordship.
55.
55, Principle 4. Lordship, here is Principle 8, Lordship. Here it states that the state level committee will meet once every 3 months, Lordship. So my name has been recommended in the year 2015 and it has
Page
been
55. Principal 4.
Principle 8, Lordship.
8.
Lordship.
State level committee will meet once every 3 months. Yes.
Lordship, wherein my name has been recommended in the year 2015,
Yes.
whereas rejected in the year 2018, Lordship, first ground. And second one is, Lordship, kindly
So
pay.
according to you, they are supposed to meet every 3 months, and the recommendation by the DLC in 2015, and they have considered in after 3 years.
3 years, Lordship. Kindly,
Therefore, they cannot say that the petitioner has there's a lapse of 3 years.
Lordship. And second one is, Lordship, kindly peruse page 58, Lordship. 58, Lordship. Last point, D, Lordship. Lordship, while disposing of the application by way of rejection, Lordship, clear speaking order shall be recorded stating the reasons of rejection, and a copy of such order shall be furnished to the applicant, Lordship.
Where it is?
Page 58, last point, Lordship, D, Lordship.
While disposing of the application by way of rejection, clear speaking order shall be recorded stating the reasons for rejection and copy of such order shall be furnished. Yes.
But in our case, the petitioner was not at all communicated, and neither the reasons for rejection or a clear speaking order was passed in case of the petitioner, Lordship.
Let us see. Thank you, Lord.
Lordship. Kindly peruse page 46, Lordship.
Yes.
It starts from page 46, Lordship, and the relevant part is on page 48, Lordship. Page 48, last, Lordship. Serial number 12, Lordship.
Page 48.
Serial number 12, Lordship.
Yes.
Serial number 2, Dibrugarh NH Division, Sri Shiva Prasad Buragohai, the petitioner, Lordship. Grade 3. Since more than 3 years has elapsed, the case could no longer be considered under compassionate ground, as compassionate ground appointment is only for immediate relief and it is not a right as held by the Lordship
Is held by
Supreme
what?
Court, Lordship.
Where it is? Where it is? Is held by?
Lordship.
You have not filed a typed copy.
I have filed a type copy also, Lordship.
Where it is?
Lordship, this is in the type copy also, it is in the vernacular, it is eligible, Lordship. So in the type copy also, Lordship, kindly peruse page 47A, Lordship. Since more than 3 years has elapsed, the case could no longer be considered under compassionate ground, as compassionate ground appointment is only for immediate relief and it is not a right as held, Lordship.
The problem is this compassionate appointment is not, the policy is no longer in currency.
Lordship, yes, no longer applicable to the present candidate, Lordship. But my father died in the year
It's
2015,
not
Lordship.
been discontinued this policy.
Lordship, new OM has come, Lordship.
Saying what?
This is in 2000, Lordship, 17, Lordship. This is that OM I have, Lordship. But this is not applicable to this present candidate, Lordship.
Thereafter also.
Lordship,
Now,
this is,
now at present there is no policy for appointment of compassionate. How can we direct now?
Lordship, but our case will be covered in
I
this.
understand, but then we'll be directing. We allow your representative, we'll be directing them.
To place my matter in the state level scrutiny
Why
committee.
there is
That's all.
nothing like that nowadays? That has been discontinued.
This 2024 one, Lordship.
Yes.
If at all he is aggrieved, he has to challenge this particular way.
Lordship, let the matter be fixed after Diwali, Lordship. I will go through it, Lordship. This 2024 one.
You have the, you may have the case. You may have points.
Lordship,
Problem is there's no policy as such,
Lordship,
and the compassionate appointment is not a matter of right.
Lordship,
It's to tide over the
Lordship.
immediate difficulties,
Lordship.
financial difficulties.
That much, Lordship.
Now when there is no policy as such,
Lordship,
that has been discontinued.
Lordship,
How can we? I mean, it's very difficult to direct them.
Lordship,
It will be futile.
Lordship. Lordship, let me go through this OM,
Because
Lordship.
policy, unless you challenge the policy,
Lordship,
I mean discontinuation.
Lordship.
What is that? 2024.
2024 one.
What does it say?
It says that in view of the circumstances mentioned above, it has been decided that no cases for appointment on compassionate grounds to the family member of state government employees who died in harness or retired prematurely on being declared permanently incapacitated for service or missing and whose whereabouts is not known prior to 31/3/2017 shall be entertained by any administrative department or authority for any reason whatsoever, nor be placed before SLCs or DLCs for recommendation of candidates for appointment on compassionate ground. For the cases of employees who die in harness after 31/3/2017 have been taken care of by way of compassionate family pension scheme in lieu of compassionate appointment, white OM dated 14/9/2017. So now no administrative authority is can consider this SLC or this no SLC or DLC.
Lordship, you can fix it after Tiwari.
Think over it.
Lordship,
We may agree with your points.
Lordship,
It could not have been ground for rejection. Your
two ground, Lordship.
yes, your could not have been a rejection. Ground for rejection.
Lordship,
However, at this stage, 24, when everything is discussed, it clearly says that prior to 17,
Lordship,
after 17, it's a family pension is given.
No.
given. Some family thing, this thing is given. So, so long as this office memorandum is in existence, it's very difficult.
Lordship,
That too, when it is brought before the notice of the court.
Lordship. After vacation, Lordship. After Diwali, Lordship.
But
even then also, Your Lordship, as the devoted Tiwari judgment stands as of today, it says that immediacy is a prime concern in any
see,
compassion. And-
you keep pending the matter, and then you cannot be allowed to say that it's been delayed. There is no immediacy. Something you cannot be allowed to.
I agree.
submit like that.
I agree about on
See,
Your Lordship, but
DFC
at the same
has
time, Your Lordship,
recommended in 2015. You have considered your case in 2018 after 3 years. Now, after 3 years, it's your fault only.
even then, Your
And your
Lordship,
office memorandum says every 3 months you have to sit.
even then also, Your Lordship, that particular sitting of SLC is not mandatory because
No,
it's a discretionary. Because
But
as a SLC,
But
as
when
such,
you have the
has to-
profess norms,
it's
when
basically
you
a
have the
guideline.
policy,
It's a
when you
guideline,
have
Your
the
Lordship.
policy in
At the end of the day, it's a guideline, Your Lordship. It is not mandatory that we have to sit because it depends on the functioning of the government authorities. And at the same time, Your Lordship, if I may have to,
you cannot say that.
if I may just state one particular paragraph from Devota Tiwari, which says that this particular
See,
delay may occur on
consideration-
behalf of the petitioner
can
or
dis-
the department. as
Sir,
such.
we understand that. Compassionate appointment is for basically for immediate.
Immediate financial. That is what.
But then non-consideration, when it was ought to be considered at a particular point of time. We have not done it. You keep it for 3 years, and then you said it's been 3 years. You cannot ever continue. That would be.
Your Lordship, I have full sympathy to the petitioner, but at the same time, Your Lordship, this particular guideline is at the end of the day is a guideline, not having any mandatory force as such.
In that case, we'll direct you to consider.
Your Lordship may kindly consider this particular fact also that this particular OM, they have to challenge this particular OM now. If they have to tide over this particular crisis, they have to challenge this OM. Because if this particular OM stands, then even if Your Lordship allows it to consider, then it will not be considered in any particular department as such, as long as this OM stands, Your Lordship. That is the difficulty.
I'm conscious.
That
But
is the
if you are
difficulty.
saying that the policy is not mandatory, then we'll pass the order.
Your Lordship may kindly let the petitioner ponder over this particular issue, and I'll also produce
So
judgments
if
to that effect.
you are sticking to your submission that is just
No,
a
Your
guideline,
Lordship.
therefore it's
Then-
not mandatory.
Then Your Lordship may kindly
We'll give reason and direct you to consider.
no, Your Lordship. Then Your Lordship may kindly take into consideration this present latest OM. Let him ponder about it, and then let him decide what to do. Your Lordship.
Second week of November, sir.
Heard Mr.
P board level.
P. Bondole, London Council for the petition. Mr. You are Mr.
D. Bora.
D. Bora, London Standing Council,
No, government advocate.
London Government, London State Council. By placing the OM dated
OM dated 18th of September 2024.
09/2024. Submits that the state has done away with the policy of appointment of persons on compulsory ground, wherein it is provided
No,
the cases prior to 2017 shall not be considered. Cases regarding claim of appointment on compassionate ground shall not be considered. And the cases after 2017 is being provided with the family pension.
Yes, compassionate family pension.
Compassionate family pension. Although this court privacy of the view that the case of the petitioner ought to have been considered in terms of existing policy of compassionate appointment back then, particularly the office memorandum of 2003. The decision of the state government to discontinue the policy of appointment of compassionate ground is to be determined. However, same has not been put to challenge as on that. Basically, next para, such situation come up. The learned counsel Mr. Gordolo praise for it is granted 2 weeks time to 2 weeks time to take necessary steps. It's your advice. Just a matter of 2 weeks.
Can I that maybe?
2 weeks.
Thank you.
We'll see. It's a really fixed position now. You may have the case, but it will be difficult. And obviously, we're not concerned that whether they will file an appeal or not, but they will take unnecessary, they will take to appeal. Because it is brought before the notice of the court.
Obliged.
More than this, I cannot give you summons.
Obliged.
May I plead your lordship? Lordship, private respondent number 5, file an affidavit case study, your lordship.
Yes.
The matter may be the
What is the matter?
lordship. The matter may be fixed after a week, your lordship. Affidavit may not be on record, your lordship.
Yes.
Lordship, I am for the respondent 5, Lordship. Starting.
Who is respondent number 5?
Lordship,
Who are you?
I'm newly appointed, Lordship, as a Anganwadi helper. And my friend has retired and subsequently claimed that I'm not retired.
No, that you are not concerned. The concern is whether his date of birth is correctly been accepted or not. That is
Yes,
the issue.
Lordship.
Yes. Which part is state?
Your Lordship, we have filed the affidavit, Your Lordship, in this
Saying
particular.
what?
Lordship, today I'm not prepared with this particular matter because the pleadings are not complete. I thought that the pleadings will complete, then the matter be heard, Your Lordship.
No, we'll see if it is the date of birth is in the school record. What is the basis of your claim? Which certificate?
Lordship, actually,
Which certificate?
Lordship, actually, I am unable. I'm unaware, your lordship, about the matter, your lordship. The matter may be fixed after a week, your lordship.
For the prayer of Mr.
M. Hussain.
Learned counsel appearing on behalf of
M.H. Lashkar.
learned counsel for the petitioner. This matter after 6 weeks, so as to enable him to file affidavit in reply to the affidavit of his filed matter, spot number 5. We have to dispose of the matter in your favor. We are taking time. 6 weeks. आराम से फाइल करके आओ.
Obliged.
Yes.
Okay, sir. Lordship, the grievance of the petitioner pertains to the action of the respondent authorities in effecting promotions from the post of senior assistant to the post of superintendent without implementing the roster, following the roster register. In fact, the petitioner belongs to the STP category, and the particular roster point against this STP a candidate ought to have been appointed. What they have done is skipped over that particular point and given
Service completed.
yes, affidavit will be required there.
Lordship, instruction received, Lordship, and sent it for, affidavit is ready, Lordship, sent it for vetting, Lordship, 2 weeks time, Lordship.
What is the affidavit? What
Affidavit
says?
stated that, Lordship, he does not, Lordship, come under the zone of consideration. That's why therefore his promotion is not considered, Lordship.
What about the reservation roster?
Reservation
Slot,
of 13
slot.
point roster is followed, Lordship. 13 point roster is followed,
30.
Lordship. 13, Lordship.
1-3.
1-3, Lordship.
What does it mean?
Means that's it. Means that then, Lordship.
Anyway,
Anyway,
first, MS, you have to come up with clear affidavit, not confusing.
Lordship.
He's claiming the reservation
Lordship.
reservation policy. Slot, which is what are the slot?
Uh,
5, 7.
Yes, 6, 7, and 9 has been filled up, skipping over RP roster point 5, and 5 is for STP candidates.
Yes, that you have to play. That's the only issue.
In roster
Yes.
point 5, Lordship, is already appointed, Lordship, as per my instruction, Lordship. We will file detailed
Now, what
affidavit,
about
Lordship,
detailed
detailed affidavit file, Lordship,
Detailed affidavit, you have to I mean,
and
this
clarify
is
the
issue.
stand, Lordship.
If you have filled up in accordance with the roster point,
Lordship,
Yes,
Better
then
than
I have
zero.
no case.
Lordship.
the method ends there.
2 weeks time, Lordship.
We file an RTA application also. In that reply, they say candidates against
There are
RT5 not
two
available.
reply.
Yes, yes.
Contradictory.
Yes, yes.
So you find out all
Lord,
this here. You
As
just-
per my instruction, Lordship, Niren Brahma was already
whatever.
appointed, Lordship.
You
Lordship.
just don't
Lordship.
heck of filing affidavit, you don't file. Issues, you have to get some of the issues.
Lordship.
Very simple issue.
Lordship.
Whether the roster point 5, slot number 5,
Lordship.
has been filled up in accordance with the reservation policy. That's all.
Lordship.
Is not it?
Yes.
D. Gurgoy and counsel for Mr.
A. Chakraborty,
H. Chakraborty.
appearing respondent 1 and 2, Lordship.
State Council.
State Council, Lordship,
State Council. Hearing for respondent number 1.
1 and 2.
Press for it is granted. For the 2 weeks time, 3 weeks time to file affidavits. So the recording is not necessary.
Record is not necessary.
No,
At this
should I
stage.
record it?
Lordship.
That the affidavit is ready.
Affidavit ready, Lordship. Send it for vetting, Lordship.
Is it clear?
It's clear, Lordship.
Is it clear?
Clear, Lordship.
List of
Obliged.
Please, Your Lordship.
Your Lordship, I am appearing on behalf of PNRD, Your Lordship. They're possible for the time being, this matter.
Why?
He is on legs there. He is coming, Your Lordship.
Is he ready for arguing the matter?
Yes, Your Lordship. Lord, it's a Kabar case by Your Lordship judgment.
Which matter?
My Lord, item 6 and 7, my Lord. Kindly see the document. This is my Lord division bench judgment, Soyed Muhammad Fazler Rabi, as well as Your Lordship judgment and some other similar judgment passed by the coordinate bench of these honorable court matter. Yes, kindly see the impugn order, my Lord. Page 60. Operating for page 62. The petitioner husband had rendered my lord the road mohara under Panchayat and Rural Development Department. His service was provincial in 1991. His initial appointment, my lord, 28/4/1961, and retired on 30/4/2000. He had rendered similar same matter,
Same department.
same matter, same department, same respondent matter. Only district is different and date of appointment.
Let him come here.
We'll hear them.
My lord.
If he agrees, we'll
My
discuss
lord,
on
my
the same night.
My lord.
After some time.
Highly obliged, your lordship. 7
7 and 8.
7 and 8.
May I please, Lordship? Lordship, matter is for compassionate appointment, Lordship. Compassionate.
Yes. MS RB Bora. Where is RB Bora? State Council. After some time.
Lordship may fix another date.
Why? It's up to you. We want to dispose it of in your favor.
But
Or
sir,
MS so and so learned counsel for the petitioner. Discount on 28/10/2024. Directed MS RB Bora, Learned State Council. To clarify the issue with regard to the recommendation of DLC and SLC with reference to the Annexure 8 and also with regard to Annexure A2 of the affidavit notice. However, MS RB Bora, the Legislative Council, is not present. MS so-and-so learned counsel for the system, phrase 4, distinctive matter after 3 weeks. They will list this matter after 3 weeks. On which date? On the next date, London State Council itself, after the election, as directed by this court, on 28/10/2024.
Lordship, date may be fixed.
We have to dispose of it. You are asking for a time.
See, is
After
not
three-
here.
It's not concerned. You should have pressed for it. This we have listed it for, in fact, disposal.
Yes.
Otherwise, why you should list it for after 2 days or 3 days? It's up to you.
Lordship will dispose. But respondent council is not present. So
Now, if I dispose of, I'll dismiss the writ petition.
Lordship.
Yes. Next. I mean, is it? No. After 3 weeks. After 3 weeks. Relax and think over it.
Well, Lordship, as per my instruction, the process is, they have taken the process, Lordship, to release the area amount.
Process has been initiated
Yeah, Lordship.
for payment
Lordship,
on the invitation.
the area amount,
Intervening period.
Lordship,
And we'll close it.
Lordship,
We'll close the matter.
Lordship.
Or MS.
Diwapanga,
Learned counsel for the petitioner.
my lord.
and also her MS
RDB.
RDB,
RDB.
and the CGC. Right. I think this repetition. The petitioner has challenged the Interim Order that is 507/2019, stipulating education qualification as one of the criteria for entitlement of nursing allowances. It is stated about the issue of payment of nursing allowances to the what is their post?
Nursing assistant, Lordship.
Nursing assistant. Assam Rifles.
Assam Rifles.
In a different medical unit of the hospital of Assam Rifles has been settled by the Honorable Supreme Court.
It is not our instruction. We don't have any instruction regarding Supreme Court case, Lordship. But our instruction is that payment is made. The relief they have sought for inheritance.
On 28th next month, 2024, this court has directed the learned CGC to obtain instruction as regard to the payment of nursing. No, is it settled, Mr. Settled before that, huh? You just give it a line. As the authorities have already remitted the nursing allowances to the petitioner for the month of September 2024. And no instruction was placed as regard the period from July 2019 to August 2024. Accordingly, this court today, MS RDB Learned CGC by placing the instruction dated 29/10/2024 issued by the Deputy Commandant. Mr. On the perusal, wherein it is reflected that the 06 into arrear bill.
Yes, Lordship. 6 petitioners' arrear bills have been already under process, Lordship, and remaining is yet to receive from the department.
Petitioners have been remitted with salary bill for the month of September 2000, and the arrear bills of the petitioner are under process for early payment. In view of the above, and as agreed to by learned parties, this petition is closed. There's no live issue remains to be determined in this proceeding. Accordingly, the petition stays closed. However, it is expected that the respondent authority shall complete the process as early as expeditious.
May I submit one thing, my lord? Kindly set some time frame. Time frame.
Already process has been initiated, Lordship. It will
As
be
early
paid.
as expeditious.
Yes, Lordship.
They are ready to pay, don't worry.
Lordship.
Even if they pay, it will go to your bank account. So it's same thing. You will not be paid cash, right?
Oh, Lordship.
Ah. The instruction, huh? The copy of the instruction shows the captain director, the market document X. Huh?
May please, Your Lordship. Can the petitioner?
Sir, it's a common case.
Malad, there's a change, Malad.
What say?
Covered case as in Malad, he's relying on that division bench judgment,
Yes.
which says that the period prior to provincialization should also be counted towards pension and pensionary benefits.
Yes.
Malad, this judgment, the principle that was laid down by the division bench, Malad, has been overruled by the subsequent judgment of the Supreme Court. Malad. Similar matter. I have a copy for your kind consideration.
So this has been, we have passed the order on 23/10/2024.
Key order. Malad, these are
Basing on the division bench
Malad.
order.
absolutely, Malad, but there has been a change in the law now.
When?
First of all, Malad, the
This is a
petition,
Supreme Court decision.
Supreme Court judgment is 2023, Malad.
Then
The principle has been overruled, Malad, by this subsequent judgment. Malad, may kindly consider this judgment because
you file an appeal because you have passed an order.
I'll file an affidavit, Malad, bringing the facts along with this judgment for your kind.
You have passed a similar order.
Malad, similar order.
Basing on the submission of the learned counsel for the parties, including the respondents.
Malad, there's
Relying on
another.
the division bench judgment.
Absolutely, Malad.
Disposed of
But Malad, there's another batch of writ petitions who have considered the subsequent.
have these petitions
It is
been
reserved.
provisionalized?
They are provisionalized, Malad.
Then
But however, the law that has been laid subsequently by the Supreme Court, it says that period prior to regularization cannot be counted towards.
that is something different. But this is a case where division bench has passed an order. You have to count that.
But the
Have you
principle,
filed any appeal or review?
the appeal was filed before the apex court.
Yes.
The apex court dismissed it in limine.
Yes.
Subsequently, in the year 2023, when similar matters came before the apex court, the apex court,
Similar, same department. From
not
the
same
state of
department,
Assam.
but same
From
facts.
the state of Assam.
Different state, Malad. It was concerning the Doordarshan, Malad. Here,
So once your appeal has been dismissed,
but they were not parties
Supreme
during that. They were
Whatever.
not parties, Malad.
Whatever.
They were fence
whatever,
sitters.
same department.
Same department, but Malad, if the principle has been overruled by a subsequent judgment of the apex
You
court,
do
can
what-
they take the
you-
benefit?
No,
That's the question.
If the Supreme Court has already decided the matter in this facts of this matter,
But Malad,
they may be conflicting and you file and you approach the Honorable Supreme Court.
Malad, now the Supreme Court has dismissed the appeal vis-a-vis the division bench. It was dismissed in limine.
Yes.
But when similar facts and similar situation arose before
In
the
that
apex
case, there's a conflicting judgment.
conflicting judgment, as in
Not
Malad,
judgment as such, in one set of case, Supreme Court dismissed. In another set of cases, some views has been given.
but the principle on which he is relying, that very
Not
principle has been struck
the
down, Malad.
principle, the order of the division bench is relying. Accordingly, we have disposed of a similar matter. And you have filed an SLP against the division bench.
No. Those are different. Malad, he is actually clubbing. Those are different cases altogether. The case which was filed on, that is a completely different set of facts. That is a completely different set of facts. Here the case is, he is seeking full pension, Malad. what the situation here is, he was initially appointed by the PRIs, by the Panchayati Raj institutions, not
Who
the
has appeared on that day? Who is Mr. Where is Mr. who
K.
is
Kumar, Senior Standing Counsel, my lord.
Yes.
Mr. K. Kumar.
K. Kumar appeared. He has agreed.
But my lord, at that point of time, the Supreme Court judgment was not brought to the notice of this honorable court.
We don't know.
My lord,
How can we have a different opinion on that?
because this
That is from different state.
and my lord, there is one more fact. There's one more fact which has been concealed before my lord. In another set of writ petitions, this apex court judgment was brought to the cognizance of the honorable bench, and the bench had reserved the order. He was the petitioner. It was before Justice UK Nair. This judgment. This judgment.
He was agree with this, my lord.
So that judgment has been reserved. He took in cognizance this judgment of the apex court,
Several other petitions also disposed of in the same.
and he appeared in the same
And
case
this is
before
the-
Justice Nair. On the basis of this apex court judgment, he has reserved the order, and he knows this very well.
Ad hoc period shall be
The stand that was taken by me, Mallet, was that the principle of the division bench have been overruled by the apex court, and the honorable court, after taking in cognizance the apex court's order, has reserved the judgment.
Also accepted, my lord. And it's separate judgment.
If the very principle has been overruled, my lord, by a subsequent judgment, how can he rely on it?
No, no, বাকি বিলাক দিছে এটা তো এলাও কৰিছে এলাও কৰি ৰিজাৰ্ভ কৰিছে জাজমেন্ট দিয়া নাই তো সিঙ্গেল বেঞ্চ বহা নাই
What is the principle? Let me see that.
Mallet, the apex court judgment. Just a humble attempt on my case side, Mallet. If my lord directs, I can file an additional affidavit and bring the facts also on record. Along with these two documents are also very necessary.
My lord, in Ranjannath,
Which paragraph?
in Ranjannath case, my lord,
Just wait.
paragraph number, my lord,
Please
19.
wait.
My lord.
Just explain the facts briefly.
It is based on Rule 13 of 1972 rules.
There's an analogous rule, Rule 36 in the Assam pension rules. 13 is analogous to Rule 36 of the pension rules. Rule 13 of the CCS, Mallet, there's an analogous provision.
Which paragraph you are relying?
Mallet, I'll just explain the facts very briefly. In this case, the apex court's judgment, the respondents were appointed as casual employees in the year 85. In 91, they are regularized. Now, their contention before the lower forum was that the period from 85 to 91 should also be considered towards pension and pensionary benefits. It should count as qualifying service, which is similar to the case that has been raised by the petitioner herein. The apex court says nothing doing from 85 to 95, the period where you rendered services as a casual employee will not be counted. From the date you were regularized, that is from 95 onwards till your date of retirement, only that specific period will be counted towards pension and pensionary benefits. It is similar to the case that has been raised by the petitioner hearing. He is seeking casual slash contractual.
Contractual no, আমার মনে কমপ্লিট contractual no,
Casual slash contractual.
আমার মনে এভোক
পোস্ট করে আসলে
এভোক পোস্ট না লাগে
আবার পোস্ট লাগে
পোস্ট করে গেছে তো সেটা পোস্ট সার্ভিস আছে কিছু
বুঝাবো এটা ইংলিশে বুঝাই দিই
What under which you are claiming this state rule?
He is claiming only the judgment, the benefit of the division bench's judgment, nothing else.
What is
Well, the division bench
No statutory provision.
What is the
kindly see the rule, my lord. Assam Panchayat
this is 1972 rules of the central government.
There's
Rule
an
30.
analogous rule in the Assam
Rule 30.
pension rules as well. Rule
And there is a
36.
clarification by Department of Personnel that the service rendered as a contractual and temporary shall not be counted for the purpose.
Casual slash contractual. He was a casual employee. Well, actually, the
No,
state,
madam.
I'll just explain the
No,
state of
madam.
It's
affairs.
okay, I've understood. Problem is that we have so many orders we have passed based on the division bench.
Per incuriam, Mellet, this apex court's judgment was never brought to the notice of the honorable court. Now I have brought this judgment before you, Mellet, and even before Justice UK Nair. Mellet.
My lord,
Similar
kindly-
batch petitions are
Kindly see
pending.
the paragraph 14 of
Same
the judgment.
petitioner,
Relying
same
on-
counsel.
Relying my friend, my lord. Paragraph 14.
The
Paragraph
per
14
incuriam.
said that, my lord, temporary period shall be counted toward pension, my lord. Here the petitioners rendered earlier was temporary period, my lord. After 1991, my lord, they rendered provincial service, my lord. Para 14, my lord.
It is very important to know the facts first.
Para 14, my lord. Kindly see.
He's just bringing it from the between. You have to understand the facts right from day one, Mellet. What had happened in the state of Assam, Mellet, it's a 3-tier system.
So are you saying that you are less bothered to file an appeal or review, but then you will drive on the basis that it is all this division bench and this coordinate bench judgment has become it's a per incurium.
Well, we are contemplating an appeal, but it's very important to stop him at least at this particular stage, Mellet, in light of the
It's
judgment.
not you. How you can stop that?
Mellet, because this judgment ought to be brought to the notice of the honorable court.
Distinguish this.
We will do it on the next date, Melody. File a short additional affidavit. Let this judgment come on record along with the additional
What
facts.
record? What judgment? Where we have seen it?
Because Malat, now I'll try to show how this case, his case and the Apex Court's case are quite similar to one another. What had happened, Malat? The PRIs, Panchayati Raj institutions, had employed casual workers like the petitioner here, left, right, and center. No due process, nothing. They were working. Suddenly, in the year 1991, Malat,
Who are you?
the government, I am for the department PNRD, Panchayati Raj department.
Panchayati Raj, who has appointed
They are PRIs. PRIs are Malat's local self-governing bodies who are working at the Gaon Panchayat level, Anchalik level, and the Zilla Parishad level. We have nothing to do with them. The department has nothing to do with them.
Yes.
So they were employed by the PRIs. They are working. Suddenly, Malat, in the year 1991, the state government in the PNRD department decides to provincialize their services, as in take all their liabilities pertaining to salary and other incidental benefits, pension, etc. Thereafter, Malat, in 91, the provincialization order is issued, which I have just placed a copy before my lord. And subsequently, in 1993, Malat, posts are created, equal number of posts, to accommodate these casual workers who were never appointed against a sanctioned post by the PRIs. Casual workers, they don't work against any sanctioned post. For the first time, Malat, in 1993, posts were created to absorb them, and in the order it was stated with effect from 1991. So prior to 91, they were PRI employees, and for the first time in the year 1991, they became state government employees. Just like in this case, in the Apex Court's case, from 85 till the date of their regularization, they were all casual workers, not working against any sanctioned post. They came into the state government's fold post the regularization order in the year 1995. The Apex Court says that period prior to 1995, that is period prior to their regularization, won't be counted towards qualifying service for counting the pension and the pensionary benefits. Only
Yes.
from 95.
As per the rule 13 of the 1972.
And in our case, 36. Assam pension rules.
Have you filed the affidavit?
I will file an affidavit.
No,
because
have
this
you
is the
filed the affidavit?
I will file an affidavit.
So have you filed the affidavit as of now?
Not till date. This is the second day this matter has come up after a motion.
Allow them to file it.
My lord, similar benefit may be given. He will file appeal, my lord, if anything, my lord.
That will come contemplating. He will not work.
Without hearing, we'll see.
My lord, my lord, the interpreter is also in a different way. Para 14 kindly see. My
Yes,
lord,
you'll be given a chance.
Let him. Obliged, Lordship.
We had disposed of the matter because other council has agreed.
my lord,
All right.
my lord.
Now he's opposing. So we'll give him a chance to file an affidavit.
Obliged, Lordship.
We'll decide. Heard Mr.
Yeah, Mr.
Learned counsel for the petitioner. In both the attempt 7 and 8, separate order, but similar.
P. Handick.
Mr.
P. Handick.
P. Handick, Learned Standing Council, PNRD, by placing the judgment of the Honorable Supreme Court in the case of Director General Doordarshan Prasad Bharati, Director General Doordarshan Prasad Bharati Corporation of India versus Maggie H. Desai. Recorded in 2023 SCC Online SC 336 semester. The principle of the principle of law is, where is that judgment? Rabi's judgment.
Page, my lord, page, my lord, 28. Page 28.
Page
28, 28. Operative part is page, my lord, 55. There are
principle of law in the judgment of the division bench in the case of the State of Assam versus Said MD Fazli Rabbi in WA 145 of 2009. Which was taken to appeal. It was taken to against which the SLP was filed. Although Honorable Supreme Court has dismissed the SLP and overruled the said principle. He further submits that he may be granted 2 weeks' time to file an affidavit, argue the matter, basing on the opposite judgment of the above judgment of the Supreme Court, basing on the judgment of the Supreme Court, as referred to here in the considering the submissions.
So I thought about 285.
3 weeks' time to file affidavit. Responding.
I am for as about 285. Both of this.
You just give your name, chronology, then you.
Lordship, I'm very much sorry, Lordship. In item number 25, I could not reach in time because due to continuation of another matter, Lordship. I'm very sorry, Lordship.
Pass the order.
Lordship,
The petitioner is not interested to take on the order. But anyway, what is your instruction?
My instruction is that post has been commonly filled up and new office memorandum has come, Lordship. Lordship,
I pass the order.
Lordship,
We'll see.
Lordship, Lordship.
Dr. Chidi.
This is your lordship.
Yes.
Here, your lordship, we need to file our counter affidavit. They have filed affidavit in opposition.
What is IA for?
This miscase has been filed challenging the order dated. That order has already been passed, your lordship, on dated 8/7/2018.
Yes.
On 9/4/2018, your lordship. MSc appeal order dated 9/4/2018, passed by the Honorable High Court, your lordship. But here, your lordship, the calculation part, if we take to our MSc miscase, your lordship, that is page 20, paragraph 6. That calculation part, we have annexed the amount they had been given, your lordship, as annexure D, page 36.
How
that
much
is
you have paid?
only 1,63,698.
Why?
Whereas another your lordship, 9 lakhs is still behind, your lordship. Till date, the petitioner is suffering, and 9,09,527 is still yet to be paid, your lordship.
The total.
And if we take to the order dated,
Total is 34 lakhs, something.
yes, your lordship.
Then
And apart from that, your lordship, if we take straightly towards the calculation part, that is on page 22, it is straightly mention everything in detail, your lordship. Everything in detail, your lordship. Page 22 of our miscase.
so whatever is paid, 30. Miscase is by whom?
Miscase filed by the petitioner, your lordship, as they have not complied the order, your lordship, that has been passed in MSc appeal. That is 284/2013. That is on page annexure A. I have annexed it in our miscase. That is page 26 onwards. It was started. The entire judgment.
Page 35 is the final.
26, your lordship, in our miscase. Page 26, annexure A. Onwards, that judgment has pronounced already, your lordship, on
Page
dated
34.
page 27,
No,
26.
page 34 is the para 13. Are you?
I'm reading from my miscase number, that is 3440/2018.
Yes.
IA petition. Petition is for 1 to 24 pages. Then thereafter, Your Lordship, affidavit 25. Thereafter, Your Lordship, Annexure A has annexed that copy of the judgment that has pronounced on 9/4/2018.
That's what I'm saying. You come to page 35, 34. Page 34.
30, yes, Your
Para
Lordship.
13.
Yes, Your Lordship. Paragraph 13.
And
13 and 35.
35 is
And it was,
the total award would now stand enhanced to rupees 34 lakhs.
Yes, Your Lordship. 34 lakhs 4,500, Your Lordship. Instead of that, Your Lordship, there is a direction time period framing has been given, Your Lordship, for 1 month for releasing, but that has not been complied by the respondents, and there, Your Lordship, the calculation.
When did you file this IA?
IA has been filed, Your Lordship, because they have not, Your Lordship, not complied with the paragraphs.
27,
Paragraph 13 and 14 of the said judgment that has been passed on 9/4/2018. Paragraph 13 and 14, that is on page 34
yes, I have seen it. Yes.
and 35.
Lordship, our liability is reduced to Lordship 50%, Lordship, of that amount. Of rupees, Lordship, 34,500, 34,04,500 was the awarded amount that was increased, Lordship, from what was given by tribunal. But our liability is held, Lordship, 50% of that amount.
Where it is?
So we have, Lordship, filed affidavit in this regard, Lordship.
Where it is?
Affidavit is there, Lordship.
Forget about the affidavit. By this judgment, 9/4/2018, where it indicates that your liability will be 50%.
Lordship, paragraph, Lordship, page 34, Lordship. Page 34, Lordship.
Yes.
Just before paragraph 13 start, Lordship. It is specifically written, Lordship, fine, there. Therefore, tribunal holding responsible. Respondent number 1 is liable for 50% of the award. Of balance, 50% of the award was not granted to the on account of contributing negligence of the deceased.
Your Lordship, here it was given, Your Lordship, 50% was not granted on the account of contributing negligence of the deceased, Your Lordship. Here, they are not able to show that this has happened due to contributing negligence of the deceased, Your Lordship. And there, Your Lordship, calculation part that I am pressing towards the page 21, Your Lordship. And there are judgment also, Your Lordship, DB bench, Your Lordship, that finding of contributory negligence, even without examining the dimension, that the deceased of the vehicle, Your Lordship, that there are some judgment is also there. The 2009-14 SSC 71 paragraph relates to 14 and 15. Contributory negligence without any findings of proof, Your Lordship.
Lordship, that is not now relevant, Lordship. Your Lordship may be pleased to go through your affidavit, Lordship. Their petition, they have admitted that our liability only now 50%, Lordship. That is 17 lakh, Lordship.
Rest who has to pay?
Rest, Lordship, he will forgo, Lordship, that amount for the contributing negligence, and that is not issue in this case, Lordship. In IA, there is no challenge regarding that.
Our prayer is, Your Lordship, very simple, Your Lordship, calculation part, Your Lordship, that has already been elaborately explained in page 21.
No, it's okay, but it says that they have agreed with the learned tribunal so far as the 50% is concerned. You just read this. So accordingly, this court is of the view that there is evidence of head in collision, which can be seen in the sediment copy so and so. is found to be applicable. Therefore, this court does not find any infirmity in the finding recorded by learned tribunal holding the respondent number 1 liable for only 50% of the award, and the balance 50% of the award was not granted on the account of contributory negligence of the judges. That has been agreed. How much? That's why I'm asking how much you have received.
Your Lordship, that is.
How much you have paid? Yes.
Lordship, our affidavit is there, Lordship.
1,60,000.
Tell us, we'll go to the affidavit if there is any
63,698.
confusion.
Annexure B, Your Lordship, page 36. I have annexed it.
Yes.
That has been released by the Registry General, Guwahati High Court.
1,63,000.
Only.
What is the 50% of 34?
Lordship, that is given in our affidavit in detail, Lordship. Lordship, maybe please to go through our affidavit, Lordship. Our affidavit is there.
Sir, बताइए on oral why you should unnecessarily go to the affidavit. Yes.
Lordship.
You are for the insurance?
Yes, Lordship.
Yes.
It
Where
is
it
in
is?
page 4, Lordship.
That
is in detail given, Lordship. Enhanced amount comes to Lordship 17 lakhs 2,250. Lordship has got that paragraph, Lordship. Then that less NFL, that is 50,000, was paid on Lordship such and such date, Lordship. It was way back in 2011 by check number such and such, Lordship. 11/5/2011, we have already paid that amount, Lordship, 50,000. Then Lordship, then lower court award was 16 lakhs 27,250. That was paid on 2/8/2013. Check numbers are also given there, Lordship. Then Lordship comes High Court order, Lordship, such and such of 25,000 paid on 30/5/18 by check number such and such. That is the balance. That is in regard to principal amount, Lordship. So now they are claiming interest on the principal amount, no-fault amount, everything that was passed, that was paid long back, Lordship.
In the
This is their plea, which is without any basis, Lordship. The interest is payable only on the principal amount. When we pay principal amount long back, the question of paying interest for 10 years, it does not arise, Lordship, at all. Lordship will find the principal amount, then what is the interest component, that is also Lordship calculated there.
very simple. How much you have paid in total? Forget about interest. Interest is on total amount, right? 9%.
Yes, Lordship.
50% of total awarded amount is 34 lakhs something. What is the 50%?
50% is 17 lakhs, Lordship.
So how much you have paid?
We have paid.
Forget that. We'll go to the. We'll come to the interest part later. Principal, you tell us. That's why I don't want to see your affidavit. Doesn't show anything. It doesn't. It makes you more confusion.
So,
Let us simplify. Why you are making unnecessarily complicated?
No, Lordship, it is.
Forget about interest first now.
Yes, Lordship.
What is the total awarded? 34 lakhs. What is the 50% of that?
50% of that comes to Lordship 17 lakhs.
How much you have paid?
2,000.
According to her, she said that only 1,63,000
No, Lordship.
or 16 lakhs.
That is, Lordship, I have to.
1,63,000.
No, Lordship.
1,63,698 only, Your Lordship. I have annexed it.
No, Lordship. That is our given in our.
From the registry.
Your
The check has been
whatever you
released.
have given, we have not seen it. It's not clear how much you have paid.
Lordship, principal amount we have written, NFL paid.
Return is not. We are not interested. How much you have paid out of the principal amount?
Lordship, I will calculate, Lordship, now. I will calculate.
Why you are filing an affidavit which doesn't give anything?
It is written there specifically, Lordship.
What is written? Tell us how much you have paid as of now. It is huge discrepancies
No,
in
Lordship.
the submissions and the affidavit.
Lordship, give me 5 minutes, I will calculate everything.
Can you make out from here?
Yes,
affidavit?
yes, Lordship. It is in affidavit, everything is written, Lordship. In affidavit, it is there.
It's okay. You give this statistics and finally you have to tell us how much you have paid as of now. Because her claim is that only
No, Lordship, no.
1,63,000 has been received.
Enhanced amount Iman. NFL 50,000 visa. Lower court award Iman. High court 25,000. তো টোটাল করা অ্যাড করা
Lordship, give me Lordship 5 minutes. I will calculate and get Lordship in detail.
নহয় তাৰে চেকখন কিমান দিছে ল' কোৰ্টত কিমান চেক দিছে
Ticket, remote calculate for you.
16 লাখ 52 আৰু তোমাৰ ইয়াতেহে দিছে ল' কোৰ্টত বাকী দিছে ৰেজিষ্ট্ৰি
Lordship, give me 5 minutes, Lordship. I will calculate and say, Lordship. Otherwise, everything is written in our affidavit, but I will again calculate, Lordship.
It shows somewhere that 16 lakhs something has been paid.
No, Lordship. It is
8 to 16 lakhs 8 to
As per the award of the tribunal, by check number, something check number is also given.
50,000 this
Are you disputing this?
25 this
Your Lordship, Your Lordship, I am going through it from my MSc in this case, Your Lordship. Since I am the new conducting, Your Lordship.
Will impose you a cost after receiving that he has given 16 something has been given somewhere by check number on 8/2/2014.
I was given this brief, Your Lordship. As that's why, Your Lordship, I am praying for counter affidavit, Your Lordship. Your Lordship, since our counter
You
affidavit.
want to file a
Yes, Your
reply.
Lordship.
You want to
Reply,
file
Your
a
Lordship.
reply. You may think of imposing a cost. The misleading.
No, Your Lordship. Your Lordship, if they have been annexed it, Your
You see
Lordship.
that the lower court or the award 16 lakhs something.
Your Lordship,
and
I
then
don't have his.
by check number, you just get it. Look at it.
I don't have his affidavit, Your Lordship. That's why I'm praying for a counter affidavit, Your Lordship.
Not counter
Since-
affidavit. You also,
Affidavit was filed,
you
Lordship.
also come clean with how much as on today you have paid.
yes, Lordship.
And you also take proper instruction.
Yes, Your Lordship.
It will be very difficult for you if we find that you have misled the court.
No, Your Lordship. I won't mislead
They
the
said
court, Your
that,
Lordship. Since
by
Your
the-
Lordship, I have not
See,
received
they
his
have
affidavit,
given
Your
the
Lordship.
check number also.
I will take
Check number and then-
proper instruction, Your Lordship.
Showing some 16 lakhs, something like that. Now you are saying that you are filing this petition saying that you have just received 1,63,000.
Your Lordship,
One
in,
lakh
in,
63
in
or
my
what?
miscase,
1
Your
lakh
Lordship,
60, just
in
check
my
the-
miscase, Your Lordship,
check
only
book,
one.
check what how much it is.
In my miscase, Your
Check,
Lordship,
check.
only one annexure
it
is
say?
annexed, Your Lordship, receiving payment, Your Lordship.
Of how much?
That is 1,63,698.
That is what you have pleaded in the IA also. All right. Is not it?
Yes, Your Lordship. I need to verify the documents, Your Lordship.
It-
Kindly give a short date, Your Lordship.
Be
Then, Your
careful.
Lordship.
Be careful to your client.
Yes, Your Lordship. I'll take instruction, Your Lordship, proper.
Lordship, I will make calculation, Lordship, if Lordship permits. Lordship. It will not take much time, Lordship. What amount we have already paid. Lordship.
Why all of us keep on trying to make the things complicated? Why not simplify? Not MS then constant body. Does
Yes, Your Lordship.
Bora?
He does, Your Lordship.
He does. Then let constant body applicant. And also have
Lordship, AJ Saikya, Lordship.
Mr.
AJ Saikya, Lordship.
AJ Saikya, then constant body opposite party. Respondent. The opposite party, respondent number 1.
Yes, Lordship.
Where's that affidavit?
Affidavit is there, Lordship. We had filed it on 19/8.
Stating inter alia that as per the lower court award, as per the tribunal's award, a sum of rupees 16,25,250 was paid to the applicant public claimant on 02/08/2023 by check number 196128. MSP does Land Council press for granted another 2 weeks time to obtain instruction as to whether how much the applicant public claimant has received, how much amount of money the petitioner, the applicant or applicant public claimant has received as on today in terms of the final order, in terms of the order of this court in the MSA. This is after 3 weeks. 2 weeks. You find out?
Yes, Your Lordship. Deeply obliged.
Lordship, our calculation, Lordship, about 20 lakhs we have paid, Lordship.
With interest?
Yes.
We'll see.
May please, Your Lordship, in this case, my Lord, as per your office note, the certificate.
So, yeah, appearing for respondent number 6.
Lordship, for respondent number 6 and 6B, I am
We'll transfer to Guwahati.
Lordship,
The hostile atmosphere.
we will file our affidavit in opposition.
What you will file?
I have just filed my
He appears to be having a big, he appears to be a big shot. Lots of influence in Dimapur.
Lordship, I have filed my no, Lordship, the respondent number.
Why you have seized him away?
Lordship,
Why you have seized him away from Dimapur?
no, Lordship, I have certain objections, Lordship. I have just filed my wakalatnama yesterday, Lordship. I will
What's
file.
there? It's a transfer of the case from Dimapur to
No,
any other court in
no, Lordship,
you
the
suggest,
respondent-
if not Guwahati, any other court in Assam or in
Lordship,
Dimapur.
Lordship, respondent number 6 and 6, A and B. Now they are the sons, Lordship. They are also there is
So
a
far as the pleadings are concerned,
Lordship. Lordship, let
From
me
the-
file my objection. I
the
have
court were not happy the way you conduct yourself.
Lordship. Lordship,
Cannot be encouraged.
let me file my affidavit, Lordship, because I have just been engaged, Lordship. I have filed my wakalatama yesterday.
You should be careful. And you should be happy that he has just asked for a transfer. We are using all these elements.
So, Lordship, let me file affidavit, Lordship. Otherwise,
That was your client. It's not done.
I will take instruction also, Lordship. But in the meantime, let me file. I have just been engaged yesterday, Lordship.
Not as a lawyer, as a judge also. I mean, as a citizen of the country.
Lordship, Lordship,
Do you like to
Lordship.
will you encourage such type of conduct?
I have not yet gone through the thing.
I have gone
brief.
through. I have
Lordship,
gone through.
Lordship. Lordship, my file fix after 2 weeks or 3 weeks, Lordship. But in the meantime, I will obtain instructions as well, Lordship. And because I have just filed my wakalatama yesterday,
There is a second history of litigation,
Lordship.
but up to Supreme Court.
Supreme Court also, my lord. So Supreme Court has remanded the matter to the Honorable Court, my lord.
We really we have a serious concern for it. That was your client.
Lordship.
Anyway, tomorrow he may say that I have not been given an HLD, London Senior Counsel Assistant.
Emroy.
MS, Emroy, London Counsel for the petition. Mr.
PM Sharma.
PM
Sharma.
Sharma, London Counsel submits that he has filed his power today only.
Yesterday.
Yesterday, on behalf of respondent number 6, Mr. Therefore, he pressed for some time to file objection. Objection to
Affidavit in opposition. Otherwise,
petition.
Lordship, I'm appearing for the stage 1 to 3.
What do you say?
I have my objection. I've already filed my
Yeah, that's already
affidavit.
filed.
Objection.
Even the state has got an objection.
Are you encouraging these elements? It will be very strange. You have filed the affidavit.
Yes, Your Lordship,
Yeah.
it's already on record.
Madam, think about it. As I said little while ago, as a citizen, can we encourage such type of conduct? We're using some elements. Not you. Your
Lordship.
It's a duty of the state. Rather, you should agree. I mean, gracefully, you should accept the prayer. Think about it. You oppose in the Supreme Court also as a state. Have you gone through?
With the letter,
Madam, have you gone through the brief?
Yes.
How you have opposed in the Supreme Court as a state? And it's a civil suit, title suit. Civil suit. Very strange. I should not comment on this. I'm referring to commenting it, but the state vehemently opposing in the Honorable Supreme Court. I find it very strange. On the basis of my little experience in the profession. That to appear by the represented by advocate, learned advocate general of this thing. Think about it, though you may have opposed the petition, but I think about the larger interest of the country or the state and the citizen. Right.
One thing, my lord, there is
you are 1, 2, 3,
And
4.
gets 1 to 3.
1, 2, 3. Who is for 4 and 5?
5, perhaps.
See,
Six,
Mr.
one and
RKD appeared personally last time for the hydro project. No?
Yes, you just informed.
My lord, one thing, my lord, just I'm pointing out, in case of DP, the DP Shula, my name may be recorded. DP Shula is out of station, my lord.
Okay.
NC does, my lord.
Oh, sorry. We get confused. Incidents.
Always true.
Huh? When do you want?
After 3 weeks, no, sir.
After 3 weeks.
After 3 weeks. Loss. Problem.
May please, Lordship. Lordship, IS file for substitution of legal heir of Lordship. This is petitioner, Lordship.
Yes.
Yes, maybe allowed, my lord, substitute. The matter will be listed for my lord admission hearing.
This IA?
Yes, Lordship.
Had Mr. Yes.
M. Bodo, Lordship.
And the counsel for the applicant. We also had Mr.
DAKU.
Learned counsel for the opposite party.
Principal respondent.
Respondent. This is an application for substitution of the legal heirs of the petitioner number 1. Namely, Samastoban BB. Yes. It is contended that during the pendency of this revision petition, during the pendency of connected revision petition, being CRP I/O bracket close 292 2023. The petitioner is appellant or petitioner?
Petitioner, Lordship.
Why you have written appellant?
Lordship, typographical mistake, Lordship.
Petitioner. Number 1 has expired. Living behind. Who has expired?
Lordship, my mother has expired. Lordship.
Applicant number 1.
Applicant number 1, Lordship.
So petition number 1 expired. Huh? Therefore, submitted the who has to substitute?
Lordship, petition number 1, Lordship.
Santar Ali.
Lordship, Santar Ali.
Santar Ali has to substitute.
Lordship, Santar Ali and Elia Khatun Bibi, Lordship.
Huh?
Santar Ali, son, Lordship, and Elia Khatun Bibi.
Elia Khatun is not a petitioner. In the CRP?
No,
No, Lordship.
because my lord, these two applicants ought to have been my lord, included as my lord, applicant petitioner in place of Samasta Bhanu.
Yes, two of you.
Yes.
Therefore, that the applicants number 1 and 2 may be allowed to substitute. This is petition number 1. Next paragraph. Mr. Leonard, counsel for the opposite party respondents clearly submits that he has no objection to such prayer for substitution, as admittedly the petitioner has expired. Having considered the submissions and the perusal of the materials, and the prayer not being opposed by the counsel to the opposite party of the respondent, I deem it appropriate to allow this application. Accordingly, the applicants, namely Santar Ali, son of late Santar Ali, and Alaya Khatun Bibi, applicants Santar Ali and Alaya Khatun Bibi, be completed in the collected CRP number 9292 of 20. We have to file an amended.
Amended मतलब cost item.
Yes, Lordship, for correction.
CRP, in view of the order passing IA 3275 which serves to the amended cost item be filed. Thereafter, the registry to.
Lordship, there is stay order, Lordship, that may be continued.
they are the strangers. They मतलब obtain expert interim order and my suit is pending. So मतलब after 2 weeks, after 2 weeks, that means after.
I allowed in that CRP you have to write a petition to file amended code. Thereafter, registry to take steps. Not take steps, registry to do the need.
The matter may be listed after 2 weeks.
Let this matter be listed after 3 weeks. Interim order for service. Higher disclosure. Yes, sir.
My lord, I am appearing for the respondent insurance company.
Who is for the petitioner?
My lord, I am respondent 1 and 2.
Who is for petitioner?
What is the name shown? Some A. Hussain Malad used to pay.
You are for 1 and 2?
Yes, sir.
You are for 3?
I am for 3.
3. All complete, service complete.
Services.
Yes.
IA is for what?
I for delay of 1,138 days.
Would like to file
Yes, my lord. Would like to file.
non-appeals for petition applicant on call, Mr.
A. Hussain.
A. Dr. Mani.
A. Datta and Mr.
R.K. Bhatra.
R.K. Bhatta, London Council for the London Councils, appeal for respondent number 1, 2, 3. The London Council by respondents are granted, have prayed for and granted, are granted 3 weeks time to file objection to the idea.
My lord, may I make a prayer, my lord? My name may be reflected in the constitution, my lord. Name is not reflected. R.K. Bhatra. For respondent number 3.
The great lawyer.
Obliged.
In the name of the R.K. Bhatta, London Council for the respondent number 3 may be reflected in the constitution. Yes.
Second wife is claiming family pension, Lordship, in this matter.
Yes.
Pardon, Lordship. Second wife is claiming family pension in this matter, Lordship. Lordship, I have instructions
To withdraw.
No, Lordship. I am for respondent, Lordship. I am respondent number 4 and 5.
So you are respondent number, you are first wife.
No, I am 4 and 5. Respondent number 4 and 5. Water Resource Department, Lordship.
Okay, so what is
Lordship, we have received a letter from the Accountant General that second wife is not entitled.
who is this? It's a Mohammedan faith.
Yes, Lordship.
We passed a similar order. Of course, that is on agreement. They have settled the matter. If the
Lordship, I have
the Mohammedan law, if one can have a 2 or 3 wives, more than 1 wife,
Yes, Lordship.
we should also be entitled. Otherwise, what is the meaning of recognizing the?
Lordship, I have a judgment of our Honorable High Court.
No, recently this court has passed, of course, on consent by the parties. If it is legally married wife and if it is acceptable under the personal law, what ails you to reject that?
Lordship, may kindly look into this judgment, Lordship.
Who is the what is the petitioner?
It is not.
When listed for what today?
Lordship, this is for today. Respondent number 6 was 3 steps was supposed to be taken on respondent number 6, Lordship.
No, it's all completed. Who has to file the additional affidavit?
Lordship, I suppose it's petitioner, Lordship.
Huh?
The petitioner, Lordship.
Service complete. No appears for the petitioner on call. Service is completed. Next paragraph. Mr.
Shi Sharma, Lordship.
Sri Sharma, London Standing Council for
Water Resource Department.
Water Resource Department. The Mr. He has an instruction to the effect that since the petitioner is the second wife, she is not entitled to family pension.
Yes, sir.
As per the rules.
Lordship, that letter has come from the Accountant General Office, Lordship.
Which has been issued by the Office of the Accountant General. In view of the above, Mr. So-and-so, London Standing Council. Water Resource Council directed to file an affidavit bringing in the court the same instruction. Who is for Accountant General? You file an affidavit, Lordship. Then in that case, Mr. So-and-so, R.
K. Talukdar.
Granted 3 weeks time to file it.
Mohsin,
Did
service
you
of
write this name? Mr.
Yeah, Mohsin
Institute
Lordship.
non-interest? Huh?
Yeah, Mohsin Lordship.
Mohsin. Your second wife or third wife?
Second wife Lordship.
As per the Accountant General, you are not entitled.
Lordship. Entitled Lordship. Lordship, she is entitled to get some.
How?
pension, Lordship. There is.
How?
Lordship, there is judgment, Lordship.
What judgment?
Division bench judgment, Lordship.
Of what?
Second wife also get pension.
In terms of division bench judgment, Lordship, that pension will be paid by the first wife, then it will be shared to the second wife.
But
Mohammedan.
in view of this court,
yes,
we have directed to pay in equal proportion to both the wives.
Yes, Lordship.
Let them fight. No, you have given an instruction to the department
Lordship.
saying that she is not
Yes,
entitled.
Yes, Lordship.
But you are making a submission that
No, Lordship, I'm
she is
not
also
making,
entitled.
Lordship. I'm stating that, Lordship, that
As per the division bench.
Yes, Lordship.
So if the division bench is it's a law now.
Full bench, man.
Full bench. So how can you have give the
The department is to forward the pension proposal in the name of first wife, Lordship.
you file an affidavit.
Lordship, service of response number 6, Lordship, complete, Lordship.
This after 3 weeks. In fact, you have to decide. Pension department has to decide. Easy. When there is a complication, only it comes to you. Yes. Yes.
May it please your lordship, my lord. My lord, here, my lord, the affidavit is read, my lord, sent for vetting, my lord, for respondent 1 and 2.
And Mr. A. Das, that is senior counsel, assisted by Mr. Counsel for deputy, Mr.
B.K. Das.
B.K. Das.
For respondent 1 and 2, my lord.
That is considered appear for
I am for 5.
respondent number 1 and 2. Praise for and is granted for the 3 weeks time to file.
Fine.
I am
Mr.
for 5.
So and
Yes,
so.
yes, I am.
You are not filing any affidavit.
No one.
So and so.
Obliged.
For
Yes.
respondent number
Yes, 5.
5. S. Mr.
S. A. Ahmed.
S.A.
Obliged.
So let me come to the respondent. Please, please.
Thank you.
May I please, your lordship.
Yes.
Kindly go for office note dated 25.
25.
25.
What does it says, Mr. Bhatt?
Some last. We have filed implement petition for finance department as a respondent number 3 in the order dated 25/6/24. It reflect as respondent number 2. Therefore, some complication to implement the respondent 3 as a respondent number 3.
So you file a fresh amended cost title.
We have already filed.
But this you have made it, the government of Assam Finance Department has been reflected as respondent number 3.
3, yes, madam.
In view of the amended cost title could not be incorporated in the writ petition, further necessary correction could not be carried out in the CI system.
In the order dated 25/6, my lord, there is some mistake.
So we'll say that in view of this office note, you file a fresh. You have filed the amended cost title as per the order of this court.
Yes.
But then the office note says that it has to be. What is that order?
Order.
Which order?
Order 25-6, my lord. It has to be, my lord.
25.
Respondent number 3.
25.
Yes, 25-6, my lord. Order dated of this honorable. Reflected as a respondent number 2, my lord.
Is allowed to be implemented as respondent number 2.
Yes, my lord. We have filed implement petition as respondent number 3, but in the order data reflected as respondent number 2. Therefore,
so he should be what?
3. It should be 3.
It's a wrongly
Yes, my lord.
recorded.
Yes.
It's okay. Although they heard and the constitutional petition. They also heard.
Respondent number 2, Lord Sir. Deputy Commissioner, Golaghat.
In the IA, you have said respondent number 2.
No. 3.
It is submitted that, in the order dated 25/06/2024. It is inadvertently recorded that the Finance Department is allowed to be implemented as, has been allowed to be implemented as respondent number 2. However, the Finance Department is to be implemented as respondent number 3. Considering that, therefore, please note, Office note dated 25/10/2024 reflects that in view of the amended cost statute, where the name of the commissioner and secretary to the government of Assam Finance Department has been reflected as respondent number 3. Necessary incorporation could not be done. Could not be done and corrected. And the necessary incorporation and the correction could not be carried out in GIS system. Having considered that the respondent number, having considered the commissioner and secretary to the government of Assam Finance Department is to be implemented as respondent number 3. It is directed that it is directed to the registry to incorporate the commissioner and secretary to the government of Assam Finance Department and respondent number 3. Necessary correction may be carried out. Carried out. What is the matter?
Rectification of.
Lordship, I am appearing for respondent number 2, Lordship, and in respondent 1 is GAD, Lordship. Kindly the name of GAD, SC GAD is reflected in the post list, Lordship.
Mr. So council for the petition. And then council, let's say standing council.
Lordship, for 1, Lordship, standing council GAD, Lordship. Reflect the name of the GAD, SC GAD.
Present. Finance?
I am appearing 2, Lordship. As
Finance
per 1 is
also.
concerned, Lordship. As per 1 is concerned, standing council.
You are for finance?
No, Lordship. For Deputy Commissioner Golaghat. 2.
For respondent number 2. The name of the, the respondents.
Number 1.
Granted 3 weeks time to file affidavit. Right? 3 weeks. What is the matter, sir?
Matter relating to the rectification of pay scale, my lord.
Pay scale.
Yes, sir.
It's a very complicated matter.
Not.
On what basis?
My junior has been given 4,720. I have been approved as 4,600.
What is the difference? How much is the difference?
Difference is 120.
Why you have been, discriminated?
My junior.
Why you have been different?
My junior has been given.
Are you not so clean?
Yes,
as a
I'm
government servant.
doing-
Yes. Granted for 3 weeks time to file affidavit. Just after 3 weeks. The name of the state, the name of the standing council.
ZAD.
ZAD be reflected in the
post.
I think that may be difficult.
3 weeks. Look at it. Which post?
My lord, LD assistant.
LD assistant. Are you on the verge of retirement?
Retired.
You have
I'm
retired?
Yes, madam. My pension is not finalized, madam. This is the problem, madam.
But the pay scale which you had drawn, it's not been finalized.
Not yet.
When did you retire? Retire?
28 to 19, madam.
19?
Yes, madam.
Still no, your pension has not been.
Provisionary pension has been
You are getting
received,
it.
yes. madam.
You are waiting for the outcome of this.
Yes, madam.
Yes, what is for? This is for?
This case was filed. This was restoration. Notice was issued, Lordship. Steps have been taken.
How many respondents?
Four.
1 to 4 notes.
Four respondents.
Office note, sir.
Delay condemnation. To delay. Delay from disposal. I disposal.
No, this delay has been condoned.
Yes, the Iowa's file was disposed, Lordship. Iowa. Iowa's disposed.
Then why has been listed today?
No, Lordship. It was not fixed today.
No, I has been listed today. MC64.
MC16 is missed case.
Delay of 34 days in filing the restoration petition has been, application has been allowed and disposed of. This has been disposed of.
But it is,
64. Why this has been listed?
it is for dismissed for non-prosecution.
MA is, lots of MC is filed.
When is the
MC.
restoration application for restoration?
I have not received lots of, we have not received the MC 64/24 lots of.
How many writ petitions? 3 writ petitions.
WPC 345 of 2020. Another 2 is disposed.
This MC64 is for what?
For
Restoration
restoration, it was dismissed for
non-prosecution.
non-prosecution. Notice was issued, Lordship, and steps have been taken in this MC.
Not IA.
MC not.
MC. No, IA should, this order should be here only. IA. Where is the IA? 2711. It should be here only. This is here. Any objection?
No, no. For restoration is concerned, let's say I have no objection.
You are for?
I am for respondent 1 to 4, all the respondents.
No, you have no objection.
No, no. The restoration is concerned.
Heard Mr. MS
It does, Lordship.
Learned counsel for the petition, and also heard the applicant. Also heard Mr.
A. Chakraborty.
A. Chakraborty, Learned state counsel for the rest. All. opposite parcel. Correspondence. This is an application for restoration of WPC number 345 of 2022, which was dismissed for non-contribution on 25/6/2024. It is next one. It is continued that the when the matter was listed on 25/26/2024, the notice of the same has been escaped, and other than the same has been escaped from the notice of the Islamic Council petition. Therefore, the Islamic Council for the petitioner has failed to obtain the matter without there being any intention of disturbance. Therefore, just afraid that the WPC number 3 understood. Expert Mr. Switch of Learning State Council. There's no objection. There's no objection to the prayer for restoration. Expert having considered the grounds that when the repetition was listed 25/06/2024. Was dismissed on when?
On 25/6.
25/6/2024.
And when you have said 22/8/2024? We consider the grounds that the listing of the matter, the listing of the requisition 345 of 2024. WPC 345 of 2022 escaped the notice of the land council petition. Land council put the applicant and the therefore restoration has not been objected to by the land council for the response. And it is appropriate to allow this application. Accordingly, the petition and then according to WPC 345 of 2020 be restored to file. I still dispose. Allowed in disposal. Then then you will have to restore that. That will be listed. You cannot pass it on.
Please, Your Lordship.
Yes.
Here, Your Lordship, notices were issued on 27/9/24 and 3/10/2024.
Yes.
The service report has not been received yet.
Award service report.
Yes.
List of the
Only, Your Lordship, the interim order that may be
interim order pass earlier.
obliged.
May I please? In this case, I need some time for taking the fresh step method on behalf of the.
Learned counsel for the petition is granted. Granted. 4 days time to.
And my lord, I have,
7 days time to take fresh steps.
I have a prayer that the opposite party number 1, 3, and 8 already died. So I may be allowed to file the subsequent.
Whatever you think.
Masood, I live.
To take fresh steps and take fresh steps and to file approved application of substitution.
Within 7 days.
7 days. Please.
Working days.
List of the
Your Lordship. Here in this case, Lordship, service on respondent number 1 and 2 is complete, but regarding 3, Lordship, there is no office note. And 4, Lordship, that IDCA, that answer notice returned back. So here in this case, Lordship, that registry will directed to put up a note regarding service report on respondent number 3, Lordship.
And
yes,
my lord, as per instruction of the respondent number 1, my lord, the respondent number 3 has already died.
expired. Then-
And I am appear for respondent number 1 and 2, my lord. And I have already filed the wakalatnama on behalf of respondent
What
number
about
6,
respondent
7,
number 4?
6, 7, and 8, my lord.
I
And
am appearing for 9 and 10.
in respect of 4 and 5, my lord, the respondent number 1 and 2 sent me the information that they have no any interested in this case, my lord. 4 and 5, my lord. But let them issue the notice, whatever they may be appeared or not appeared, I don't know, my lord. Just send me that information, my lord. They are not interested.
You take fresh steps on respondent number 4.
Yes, I will take fresh steps on respondent number 4.
And the other 5 to 8 you are appearing.
No, my lord. I am appearing for 6, 7, and 8, my lord.
6, 7,
8.
Regarding
In that
5,
case, you just
4 and 5. I will
4 and 5 take it. Then counsel for the petitioner. No, not Mr.
Yeah, me.
Let me counsel for petitioner. MS
K. Pukal.
Efukan London State Council
Yes, Your Lord.
appears for respondent number
9 and 10.
9 and 10. And then end it before you just keep it for that.
Yes, ma'am.
1 and
1, 2, 6, 7, and
6,
8.
7, 8.
My lord. Yes, sir, ma'am.
Then counsel for the petitioner to take fresh steps for service of notice about respondent 4 and 5.
No.
You got the information, then whatever you want to do,
Yes,
for
ma'am.
respondent number 3, you do it.
Lordship.
Say it is
Lordship, I will take that.
expert. Within 7 days.
Oh, yes, ma'am.
Just after 4 weeks.
Yes, ma'am.
Interim order is there, that may be.
Interim order for service.
Please, my lord.
May it please your Lordship.
Yes.
Lordship, this is a delay petition because our MSc appeal was dismissed for non-prosecution. And the reason we are shown, Lordship, in the cause list, our name was not shown. On that day, in fact, we appeared for other cases. So here, since name of other councillors, it escaped our knowledge.
The IA for what?
I for delay condonation of 44 days, Lordship.
In filing restoration petition.
Restoration also we have filed, Lordship, another application. Two 566 is for condonation of delay.
Any objection?
No, my lord, no objection. My lord, this may be restored, my lord, and matter may be fixed for hearing because it is a matter of.
No, first we'll let it
Yes,
be
yes,
restored
yes.
and then only
Then-
raise to you.
Yes.
Heard MS Adi Majinder, the counsel for the applicant, and also heard
Okay, but check.
K. Bhattacharya, land counsel for the opposite party.
Number 1, respondent number 1.
Who else are appearing?
Respondent.
What about others?
Others, my
Others,
lord, I think it is
they are not
expired. They are not-
necessary because Lordship in the appeal also mainly on the quantum only. And before, earlier also, I think they did not appear. And
The owner
that-
and
This is
the
an application,
driver
section
admitted
5 of
No.
Indian Limited Select.
quantum no, to the
Supreme Court.
insurance.
Dependent no.
No.
In filing an application,
They are not insured. Nothing will be taken to after an accident.
for restoration,
Oh. Mix up political case.
filing a miscellaneous application for filing a
At the time of accident,
connected
insurance to the accident.
MC, application for restoration. The delay, accumulation delay of 44 days in filing the application for restoration of the MSc appeal number 2024. So 244 of 2013, which has been dismissed, which was dismissed on when?
Dismissed on.
It was dismissed twice, my lord. Earlier also it was dismissed.
Anyway,
No, no.
last one.
25 to 2024.
20, when 2005 2024.
I have explained it in paragraph, Lordship.
Paragraph which?
3 to 11, Lordship.
The learned concept of the applicant.
When we searched for the Lok Adalat list, Lordship, then we found that this case was shown as disposed of, then dismissed. Then we checked the order. We found that it was dismissed on 25/2024. Then immediately we filed the petition.
It is contended that the when the matter was when all other matters are listed in the Lok Adalat, the counsel for the applicant found that the MSc appeal number 244 of the 2013 has been dismissed for non-prosecution on 20/05/2024. The cases, the appeals on behalf of the applicant are being taken up by different set of lawyers. In the present case, in the connected appeal, after the dismissal, the present counsel was engaged on it is found that when the matter was listed on 20/05/2024, the engaged counsel, the name of the engaged counsel was not shown in the cause list. Therefore, the engaged counsel the notice of the matter has escaped the notice of engaged counsel. The applicant. It says there's no deliberate intention. There's no intention not to appear in the connected when the matter was listed. Mr.
K.
Bhattacharya and counsel for the opposite party one responding clearly suggests that he has no objection in condoning the delay of 44 days in filing the connected application for restoration of the MSc appeal number 244 of 2013. Next, having considered that the applicant could show sufficient cause of not preferring the appeal, without preferring the connected application for restoration of the MSc appeal 244 of 2020, which has been dismissed. Dismiss on I deal with the project. Follow the application. As a sufficient cause has been shown. I'm satisfied that the sufficient cause has been shown in not preferring the connected application for restoration for the time accordingly. The delay of 44 days in filing application for restoration is conducted. I stance allowed.
There is another IA Lordship 2849 of 2024. That is for restoration.
Restoration, same application for restoration, same order. Where is your ground?
Lordship, same ground because the cause list, Lordship, here also have annexed the cause list on that day.
Almost same ground. And no objections.
No.
Same. We'll slightly change the restoration. The accordingly MSc appeal number 244 of 2020.
2013.
2013.
13, that's one.
Okay, 2013. Then you said MSc has agreed. Restore to file. The IA stance.
It was supposed to be listed for hearing. Lordship can fix it
We'll
for
see.
hearing.
Let them restore.
Okay.
Restore.
Yes,
In view of this, they will do
Fine, Lordship. Highly obliged, Lordship.
22.
May it please Lordship.
Yes.
The IA is for substitution. During the pendency of this instant case,
Do you have any
the petitioner
objection?
expired.
She has made the application for substitute the.
Do you have any objection?
No.
You are for?
For all the respondents.
MS. Her MS
Tiwa Pangula.
under counsel for the applicant and also her
PK Medhi.
PK Medhi
Yes, Lordship.
for
respondent, all the respondents.
all the respondents.
Yes, Lordship.
You are?
I am in item number 33 minus
23.
23 minus WPC 4051.
No, it's okay.
For all the respondents.
It's for all the IA only.
Yes.
Today is listed for IA only.
Yes.
Isn't it?
Yes.
23.
Lordship,
has been-
Lordship, petitioner is same petitioner.
Same
Lordship.
petitioner, my lord.
Two cases, Your Lordship.
Two pending cases. my
Yes,
lord.
Lordship.
IA in IA.
Yes.
You are
22.
not applying.
I is for 22 item number.
This is listed because it's a similar matter.
Yes, my lord.
Same matter, similar matter, therefore listed together.
Different matter,
Benefit is defined.
different matter, my lord, but it's the same person,
Same person.
my lord, same person.
Then why benefits?
But she
One-
has filed different petition, Your Lordship.
One of the petition has been, substituted.
And consequent position and so and so, huh? Applicant, huh? In IA. By filing this application, the applicant has sought for has prayed for substitution of the petitioner by his legal representative, in bracket the applicants. Who is the applicant?
Wife, my lord. Wife of petitioner.
What is his name?
Annexed to is the document.
Huh? What is your name, applicant?
Page three,
Lordship. Page 3. Alka Yadav, Lordship.
Okay.
Wife of the deceased petitioner.
Namely, Srimati Alka Yadav. Huh? In a connected with petition in WPC 5424 of 2020. It is contended that during the pendency of the current petition filed by during the pendency of the writ petition, above writ petition, the petition expired on 19/07/2022, leaving behind applicant Mr. Therefore, the applicant being the wife of the deceased petitioner may be allowed to be substituted. Mr. So-and-so learned constituted opposite party respondents has no objection to the prayer for substitution as the petitioner has died during the pendency of the petition. Having considered the submissions and the materials on record, I deem it appropriate to allow this application is the recording the applicant, namely Srimati Alka Yadav, be implemented, be substituted in place of the deceased petitioner. Next, the application, the IA stands allowed in disposal. Next page. In writ petition, publication, 542. Schedule the order for the petitioner. The land constitution file amended cost. That's all. List after. List this matter after 4 weeks. 4 weeks.
And both term may be taken, my lord.
Then list this matter after course along with
Item number
WPC
23.
4051. 4051.
The case is removal of service petitioner is
Yes. You produce, you do have the records. Last occasion you
Yes, my lord.
directed to obtain,
okay in the record, madam.
produce the records. Do you have the records?
No, madam. Sorry, madam. I forgot to bring the record, madam. Maybe taken after 1 week, madam. Petitioner is
Who is the petitioner?
petitioner is
Last
AK
time
Sharma.
also he did not appear.
AK Sharma.
He did not appear last time also. We'll
Last
see
time
next
I
time. No one appears for the petitioner on call. When the matter was listed for hearing on 1909-2020. Petitioner was also not represented. Mr. MS
A Gayan.
A Ganguly.
A Gayan.
A Gayan. A Gayan. None is CGC. His brother granted 3 weeks time to produce the report. As all by, as directed by this court. This after
After 2 weeks.
3 weeks.
3 weeks. Must come, madam.
Lordship.
Yes.
Lordship, in item 13, I was for petitioner, but I am assuming that my item is 23. That's why I could not appear. Non-appearance may be omitted, Lordship. On this.
Item 13.
1-3, Lordship.
What
Water
do you
supply.
have to say? So,
Only non-appearance may be omitted, Lordship.
so you have confused yourself as
Lordship.
23.
But my item is
So
13,
this
Lordship.
item is the IA is for what?
For condemnation of delay, Lordship.
Of what?
For in preparing this
How many days?
1,138
Okay.
days.
So you will have to issue notice.
Lordship.
Notice was issued.
Notice was issued.
Issued. Any? Huh?
Lordship, matter was fixed after 3 weeks. That may be only non-appearance may be omitted, Lordship.
No. What about that? Whether the service notice service?
They have appeared, Lordship.
Huh?
A respondent on the respondent appeared, Lordship.
In that case, item 13. Heard, Mr.
A Hussain, Lordship.
If they appeared, we could have decided the matter, disposed of the matter. If
Lordship,
it is-
I'm sorry, Lordship. I am sitting in the courtroom, but I'm thinking my item is 23, Lordship.
They have appeared.
Appeared, Lordship. Appeared. They have appeared.
They have talked for a time. 2 weeks time to file affidavit. In that case, heard.
A
Instead
Hussain.
of non-appearance, heard.
A Hussain, Lordship.
A Hussain learned counsel for the applicant. Just that. Rest will remain the same. I think they have sought for a time to file. They have served a time for filing objection. You see?
Master.